Hello, my name is Stephen Pevar, and I've been asked by the Office of Tribal Relations to discuss with you today tribal sovereignty, the inherent right of Indian tribes to be self-governing. My own background is I have litigated a number of cases on behalf of Indian tribes and their members. For more than 20 years, I have taught federal Indian law at 3 different law schools and currently teach that course at Yale Law School. And I'm the author of The Rights of Indians and Tribes, and I've written extensively on the topic of tribal rights. So today we'll be discussing tribal sovereignty, perhaps the most important right that Indian tribes have, and indeed it is the most important right. Indian tribes have a number of rights: the right to hunt and fish, to tax, to regulate their own land. But the most cherished and the single most important right that Indian tribes have is the right of inherent sovereignty. If tribes lose the right to be self-governing, then they cannot protect any other right that they have. About a year and a half ago, I attended a conference where Jefferson Keel, who was then the president of the National Congress of American Indians, was speaking about tribal sovereignty. And I took some notes about how he described tribal sovereignty. And one of the things he said is, tribal sovereignty is not conditional. Tribal sovereignty is absolute. Well, let's start out in discussing tribal sovereignty by defining what we mean by sovereignty. What is it to be sovereign? A dictionary definition, and there's a legal dictionary called Black's Legal Dictionary, defines sovereign government as a government vested with independent and supreme authority. That is a government that has the power to make its own laws and to be ruled by them and to enforce those laws. Well, under a dictionary definition then of sovereignty, sovereignty is all or nothing. You either are sovereign, you either have supreme authority, or you don't. Some other government is telling you what you could do or limit your authority. Well, viewed that way, it might be argued that Indian tribes are not sovereign governments. There are 3 ways that different commentators have viewed tribal sovereignty. 2 are what you might say extreme positions, and then 1 is a middle position or compromise. The first is, yes, Indian tribes are sovereign. They have always been sovereign, and they are as sovereign as the United States or any other nation. This is the position that is taken by the vast majority of Indian tribes. As they see it, they have never lost their sovereignty. And the United States should not continue to view them as anything less than fully sovereign governments. The other extreme, and again, I don't mean to say that these extreme positions are not rational positions, but they're at the outer ends of the spectrum. The other extreme position is no. Indian tribes are conquered nations. They no longer have any sovereignty, and it's wrong for the United States government to even view them as sovereign in any respect. And most of the people who espouse that view are non-Indians, who want Indian tribes to have a diminished authority in the United States today. The third position is the one that is taken by the federal government, and that is that yes and no. Indian tribes, and I'm quoting here from Supreme Court decisions, are quasi-sovereign. They have attributes of sovereignty. They're no longer fully sovereign, but unless the federal government has removed powers that they inherently have, they continue to have a right to exercise the powers that they have always had. However, the Supreme Court and Congress have taken the position that Indian tribes in the United States today are subject to the supreme authority of the federal government. And this is known as the plenary power doctrine, that Congress and the United States government has plenary power over Indians and Indian tribes. The Supreme Court has developed this so-called middle position or compromise position in a long line of cases beginning in the 1820s. One of the most recent decisions that summarized nearly 150 or 175 years of precedent is a decision issued by the Supreme Court in 2004 that I'll be discussing a little later. And in that case, United States versus Lara, the Supreme Court reaffirmed several principles. One is this plenary power doctrine. And quoting here from the decision, the Constitution, and I want to emphasize that because I'll talk about that in a second, the Constitution grants Congress broad general powers to legislate in respect to Indian tribes, powers that we have consistently described as plenary and exclusive. The second principle that the court reaffirmed in Lara is, however, those rights not removed from tribes as part of their inherent sovereignty remain in effect. So again, quoting, Indian tribes are unique aggregations possessing attributes of sovereignty over both their members and their territory. So Lara, again, reinforces and reaffirms a long line of Supreme Court cases recognizing these two basic principles of inherent tribal sovereignty. I would be remiss if I did not take at least a couple moments and talk about the criticism registered largely by Indians and tribes, but by many other people and commentators, the criticism of the plenary power doctrine. Where does the United States get off, to use the critical language, get off asserting power over Indians and tribes? All three branches of government, Congress, the executive branch, the agencies, and the president, and then the courts, all three branches of Congress have long presumed that the plenary power doctrine exists and is legitimate. But if you look at the United States Constitution, there really is nothing in the Constitution that confers plenary power over Indians and tribes. What the Supreme Court has cited to, because this is the only thing that is in the Constitution to which they could cite, is what's known as the Commerce Clause. And the Commerce Clause is one sentence, and it says that Congress has the authority, quote, to regulate commerce with foreign nations and among the several states and with the Indian tribes. That language confers no more authority over Indian tribes than over foreign nations. In the same way that the United States would never claim to have authority to regulate England and France, with whom Congress can also regulate commerce. At least reading the the language itself, the Commerce Clause confers no greater authority over Indians and tribes. And yet, this is the clause that the Supreme Court has consistently relied on for exercising plenary authority over Indians and tribes. Numerous commentators and political figures have criticized the Supreme Court's assertion of authority pursuant to the Commerce Clause. I'm just going to quickly cite two of them, and then we'll move on. The plenary power doctrine is well established and well settled, and I'm not going to continually say that there's anything wrong or inherently indecisive about the plenary power doctrine, but I do want you to understand that it has been criticized. Walter Echo Hawk is an attorney, a Pawnee, who's written a number of books, and in one of his more recent books he wrote, "The plenary power doctrine was seemingly plucked out of thin air by the Supreme Court," because again, there is nothing of substance in the Constitution that one can cite to it. Bear in mind, the Constitution was written in 1787. In 1787, Indian tribes were enormously powerful. I doubt whether any person living in 1787 had the concept that merely because the United States obtained its independence from Great Britain, somehow our government acquired authority over these fierce, resolute, independent Indian tribes that were living amongst us and outside of the 13 states. So again, the Commerce Clause wasn't written and couldn't have been written with the idea that the federal government had plenary power over those Indian tribes. And secondly, Frank Parmersheim teaches federal Indian law at the University of South Dakota, also has written a number of books. And here's a quote from him, saying that the plenary power doctrine was adopted by the Supreme Court to justify federal land acquisition, the taking of Indian land, and to assert power in Indian affairs. Well, again, now we'll spend the entire rest of the time talking about the doctrine of tribal sovereignty given the plenary power doctrine. And I'm not going to refer back to criticisms of it. I will leave that, of course, to each of you to determine for yourselves whether it's a legitimate doctrine or not. There are three principles regarding tribal sovereignty. The first is that Indian tribes do indeed retain certain inherent powers of a sovereign. And we will be discussing examples, particularly court decisions, illustrating each of these three principles. So the first is that tribes have inherent authority. The second is the plenary power doctrine, that Congress, however, has the power to limit or abolish all authority of Indian tribes. Indeed, Congress can even terminate, obliterate, abolish an Indian tribal government entirely if it wishes. And third is, in addition to the express limits that Congress has placed from time to time on Indian tribes, there are what the Supreme Court has called implied limits, certain limits on tribal power that are there even if Congress hasn't expressly said that those limits exist. So let's now look at some court decisions that created or recognized each of these three principles. The first principle is that Indian tribes retain inherent powers. One of the earliest cases that established this principle is Worcester versus Georgia, decided in 1832. And very quickly, here are the facts. The federal government had entered into a treaty with the Cherokees and created a reservation for the Cherokees within the state of Georgia. This, of course, was years before the Civil War, which finally settled the question of which power overrules the other power, federal or state. And this was actually one of the early cases that was a catalyst for the Civil War, because Georgia resented the fact that the federal government had taken land away from the state of Georgia and created a reservation for Indian tribes. Today we accept that concept, and there's more than 300 Indian reservations in the lower 48 states, but early on there was considerable dispute as to whether the federal government indeed had the authority to take land away from states and create reservations for tribes. So Georgia wanted to flex its muscle and to test the theory that the federal government could take state land for Indian use. And it passed a series of laws that was designed to dilute federal authority in Indian country. One of these laws said that no person, no non-Indian, could enter the reservation without Georgia's consent, without getting a permit from the state of Georgia. The Cherokees had set up a church within the reservation, and they invited a man named Samuel Worcester, who was a minister, to come and lead the congregation. Worcester did so, was happy to do so, and although he was aware of that permit requirement, felt that Georgia had no authority over him or the tribe, and he accepted the invitation and went onto the Cherokee reservation without getting the permit. Georgia wanted to test its power, and it sent its police onto the reservation, arrested Samuel Worcester, again, who's a non-Indian, took him off the reservation, prosecuted him in a Georgia state court, found him guilty, and sentenced him to the maximum punishment of 4.5 years in prison for not getting that permit. He appealed his conviction to the U.S. Supreme Court, and the Supreme Court reversed, holding that, first, Indian tribes have inherent sovereignty. They have authority over their territory, and they always have. This was the original lands of the Cherokees, and that Congress has the authority to create these reservations. Here is some language directly from Worcester versus Georgia. Indian nations had always been considered as distinct, independent political communities, retaining their original rights as the undisputed possessors of the soil from time immemorial. The Cherokee Nation, then, is a distinct community, occupying its own territory, with boundaries accurately described in the treaty, in which the laws of Georgia can have no force, and the citizens of Georgia have no right to enter, but with the assent of the Cherokees themselves, or in conformity with treaties and with the acts of Congress. Before we move to the next case, I want to emphasize two things in Worcester versus Georgia. One, which is obvious, and that is that Indian tribes are inherent sovereignties, and states are subservient to that, or they have no right to exercise their authority in Indian country. But the second thing I want to point out is the last few words in the quotation we just reviewed, and with the acts of Congress. Worcester versus Georgia really sowed the seeds for the plenary power doctrine, because this says that today Georgia has no force, but Congress could change that if it wishes to. The next case that also reaffirmed the concept of inherent tribal sovereignty is Talton versus Mays. And here are the basic facts of Talton versus Mays. The Cherokees in Georgia, as we know from Worcester versus Georgia, were living in Georgia, as they always had lived in that area. However, in the 1830s, Congress enacted what are called the Removal Acts. President Jackson forced them to leave Georgia to the applause of the Georgians who had wanted their land all along, and remove them to what was then called Indian Territory and is now the state of Oklahoma. So this case deals with the Cherokees who are now in Oklahoma. The Cherokees had been residing in Oklahoma now for some 50 or 60 years, and they had established their own court system, a very sophisticated government and judicial system. And Talton was a member of the tribe. Talton was arrested by tribal police for having murdered 2 other members of the tribe. And he was prosecuted in the tribe's own court. He was found guilty in the tribe's own court and sentenced to death. The Cherokees were actually one of the few tribes that had capital punishment. The vast majority of tribes did not. He was sentenced to death. He appealed his conviction and asked the United States Supreme Court to review the manner in which he was prosecuted and tried in tribal court. And he filed his appeal alleging a violation of the Fifth Amendment due process clause. One of the most important rights you and I have under the United States Constitution is the right to due process of law under the Fifth Amendment, that the federal government cannot remove our life, liberty, or property without giving us due process, which in most cases involves notice and an adequate hearing or trial. Talton alleged that the tribal court proceedings did not comply with due process. And indeed, the tribe acknowledged that there were certain things, particularly a grand jury indictment that is required by another provision in the Fifth Amendment, that the tribe didn't have. They tried Talton the way the tribe felt was fair and just, but it did not comply with all of the things that you and I would get under the federal Constitution if we were prosecuted in a federal court. So the issue before the Supreme Court was whether or not when Indian tribes try and prosecute their own members in tribal court, they must provide to those members the same rights that you and I, or even Mr. Talton, would get in a federal court under the U.S. Constitution. And in a decision that really might surprise most people today, the Supreme Court ruled Indian tribes are inherent sovereignties. They can operate their own courts however they wish. And they do not have to provide to persons in tribal court the rights that are contained in the United States Constitution. In other words, you do not have, and Mr. Talton did not have, constitutional rights in a tribal court. Tribal courts and Indian tribes long preceded the U.S. Constitution. There's nothing in the Constitution itself that imposes its obligations in tribal court, and therefore you don't have constitutional rights in a tribal court. Here are a couple sentences from Talton versus Mays. It cannot be doubted, as said in Worcester, that the Indian nations had always been considered as distinct, independent political communities, retaining their original natural rights. Because the powers of local self-government enjoyed by the Cherokee Nation existed prior to the Constitution, they are not operated upon by the Fifth Amendment, and therefore tribal courts can operate however the tribe wishes. As a quick footnote, in 1968, Congress passed a law known as the Indian Civil Rights Act. That law imposes on tribal governments nearly all of the rights that are contained in the United States Constitution. So today, if you were prosecuted by a tribal court or involved in a tribal court proceeding, you would have the rights that are contained in the U.S. Constitution, but not as constitutional rights. You would have them as statutory rights, rights that were conferred upon you and on all tribal members by Congress through the Indian Civil Rights Act. Here's one last case illustrating inherent tribal sovereignty, and that is Williams versus Lee, a more recent case, 1959, and here are the basic facts. Ms. Williams is a Navajo, a member of the Navajo tribe. Lee is a owner of a trading post located on the Navajo reservation. Williams bought some goods from Lee, and Lee contended that he lent money to Williams to purchase the goods. In other words, that she bought them on credit, and that she never paid him back. So Lee had some choices here. He could sue the Williams family in tribal court, in the Navajo tribal courts, because the Navajo government had set up its own court system that permitted non-Indians to sue tribal members for contract disputes arising on the reservation. Or he could sue in state court. Both Ms. Williams and Lee were citizens of the state, and there appeared to be no reason why he could not sue her in state court, just as if she were a non-Indian in that situation. Without question, he could have filed suit in state court. He did select state court rather than Ms. Williams' tribal court. He obtained a judgment against Williams. Williams then appealed that. The Supreme Court took the case and reversed, saying that Indian tribes are inherent sovereignties. They have set up their own court system. And Lee didn't have the right to compel Williams to litigate this claim in a court other than the one the tribe had set up for this purpose. And here's just one sentence from the Supreme Court decision. It is immaterial that respondent, and respondent was Lee, is not an Indian. He was on the reservation, and the transaction with an Indian took place there. So once again, this is another example of the Supreme Court declaring loud and clear that Indian tribes are inherent sovereignties. They're not even subject to the restraints imposed by the United States Constitution. They have authority over non-Indians, and they could set up their own court systems and their own government however they wish. And indeed, in Worcester versus Georgia, that state law is inapplicable on Indian reservations. So that's principle number one. Now let's turn to principle number two, and I'll give you some examples of the plenary power doctrine. The first is Worcester versus Georgia, which we needn't go through once again. I pointed out the quotation there in which the Supreme Court said that although Indian tribes are inherent sovereignties and state law is inapplicable, Congress has the authority to change that if it wishes to. The next case to discuss is Lone Wolf versus Hitchcock, decided in 1903. And here are the basic facts of Lone Wolf. In 1867, the United States government entered into a treaty with 3 tribes, the Apache, the Kiowa, and the Comanche. And those 3 tribes relinquished vast land holdings in exchange for a much smaller reservation and a guarantee that they would not continue hostilities against the federal government. In exchange, the federal government, through the treaty, promised these tribes several things. One of which these tribes were quite astute in insisting upon, because these tribes had seen that the federal government had previously entered into many treaties guaranteeing those tribes that the land being reserved would never be diminished. And yet, hardly the ink was dry when the United States changed its mind and forced the tribe to relinquish even more land. So these tribes, and a couple others in the same period of time, came up with what they thought was a brilliant safeguard. Their treaty states that no additional land would ever be taken from these tribes unless the federal government convened an election and at least 3/4 of the tribal members, it actually says adult males, voted in favor of relinquishing more land. And the tribes felt quite confident that tribal members would never vote to give up more land. So this seemed finally like an excellent safeguard against what was happening to so many other tribes, where the federal government promised to reserve lands and then broke that promise. Well, again, this treaty was 1867. 4 years later, 1871, Congress passed a law ending treaty making with tribes. And after 1871, Congress could then pass laws dealing with Indian affairs. As non-Indians moved out into where this reservation was in the Kansas area, non-Indians wanted some of the land that had been reserved by this 1867 treaty to those tribes. The federal government asked the tribes to relinquish land. They said no. The federal government then performed the election under the treaty and lost. The tribes refused to accede to the federal government's request of giving up more land. Undaunted, the federal government, or Congress, then passed a law removing the land anyway, in clear violation of the treaty. Under the treaty, the only way that the federal government could ever take land from those tribes was through an election, which the government had tried and failed. Lone Wolf was a Kiowa chief. He sued Hitchcock, who was then the Secretary of the Interior, alleging a violation of the treaty, which on its surface it clearly was. The issue before the Supreme Court, however, was, does Congress have the right, the authority, to break a treaty by passing a statute? And the Supreme Court held that it does. In the same way that Congress can amend or repeal an earlier statute by passing a later statute, the Supreme Court held in Lone Wolf, Congress can do the same thing with a treaty. That treaties and statutes have equal dignity, and that Congress, through the simple expedient of passing a law, can overrule or abrogate or breach a guarantee that our government made to an Indian tribe. Many people believe that this is the lowest point in U.S. relations with Indian tribes, because clearly, regardless of whether you believe that Lone Wolf is a correct decision, in other words, that Congress does have plenary power, you still have to understand that we broke our promise. We secured certain rights to the tribe. They then relinquished their land. They fulfilled their part of the bargain. And now we're going back on our word. A few minutes ago, I cited a quote from Walter Echohawk, who had written a book about the 10 worst cases ever decided by the Supreme Court involving Indian rights, and this is number one. Clearly, Lone Wolf is a low point where our country frequently criticizes other nations for breaking treaties, and yet this is exactly what happened here. In any event, this is a clear example of the plenary power doctrine. Congress even has the authority to break a guarantee that we have given to Native Americans through treaties. The final example of the plenary power doctrine is the Lara decision that I was quoting from earlier, and I said I was going to discuss it later. Now is later. Here were the basic facts. First of all, in 1990, the United States Supreme Court decided a case called Duro, D-U-R-O, versus Reina, R-E-I-N-A. And in that case, the court said that Indian tribes do not have the inherent authority to arrest and prosecute in a tribal court non-member Indians. That is, an Indian who belongs to another tribe and who is visiting the reservation. If a non-member Indian, let's say I'm a Navajo visiting a Sioux reservation and I break tribal law, the tribe, the Supreme Court held in Duro versus Reina, cannot arrest and prosecute me because I'm not a member of that tribe. Well, 1 year later, indeed even less than 1 year later, Congress passed a law essentially reversing that and stating that, indeed, Indian tribes do have the inherent authority to arrest and prosecute non-member Indians. Lara was a non-member Indian. That is, he was a member of one tribe who went to another reservation, broke the law of that tribe, and was prosecuted and found guilty in tribal court. He appealed his conviction, and the U.S. Supreme Court took the case to determine who wins. Does the Supreme Court decision prevent Congress from essentially legislatively overruling what the Supreme Court held? And the Supreme Court said, yes, Congress has plenary power. Congress has the final word with respect to what Indian tribes can and cannot do. And essentially, we got it wrong. Duro versus Reina was incorrect. We thought that Indian tribes lack that authority, but we don't have the final word. Congress does. Now, as a quick footnote, if the Supreme Court had held that it was unconstitutional for Indian tribes to exercise that authority, then Congress could not have changed that. A constitutional ruling can only be changed through a constitutional amendment. Duro versus Reyna simply interpreted what tribal powers are, and it was not a constitutionally based decision. It was a decision in which the U.S. Supreme Court reviewed Worcester versus Georgia, Talton versus Mays, and said tribes don't have this authority. As a non-constitutional ruling, then, as the Supreme Court said in Lara, Congress had the prerogative to change that ruling. So today, indeed, non-member Indians can be and are being prosecuted in tribal court for breaking the laws of their visiting tribes. So that are examples, those three cases are examples of the second principle, the plenary power doctrine. I'll give you one case illustrating the third principle, that in addition to the powers that Indian tribes have lost as a result of what Congress has done, they also have lost some other powers. And that was established in a case in 1978, Oliphant versus Suquamish Indian tribe. And here are the basic facts. There were actually two cases accepted by the Supreme Court and combined into Oliphant. I'll kind of combine the facts of those two cases. It involved a man named Oliphant and another man named Bellegarde. Oliphant went to the powwow put on each year by the Suquamish Indian tribe in the state of Washington. According to the facts in the record, he got drunk. He went on to the powwow grounds and interfered with some of the dancers. When tribal police tried to escort him off, he punched one of the police officers in the face. Later, in the other case, Bellegarde had a somewhat similar situation. Bellegarde was trying to elude tribal police, weaving down tribal roads. They stopped him only by ramming a tribal car into Bellegarde's car, forcing him off the road. Both of those situations involved non-Indians who clearly broke tribal law, and indeed in Bellegarde's situation could have killed tribal members on the reservation. Both were prosecuted in tribal court, found guilty of violating tribal law, and sentenced to tribal jail. The issue before the Supreme Court was whether or not Indian tribes have the authority to arrest and prosecute non-Indians. The tribe used the Worcester Principle, and under the Worcester Principle, the law was, and had been for almost 150 years, that Congress has plenary power, and that unless and until Congress limits tribal authority, tribes can exercise their inherent rights. And the tribe said, of course, we have an inherent right to protect our safety and security. These men hurt and could have further injured or killed tribal members. Clearly, just like any state or the federal government, we have a right to prosecute and prevent this kind of harmful behavior in our community. And they further said, Congress has never passed a law prohibiting or limiting our criminal jurisdiction or criminal authority in that respect. Many people believe that the United States Supreme Court wanted to hold that Indian tribes lack criminal jurisdiction over non-Indians. And because the court was unable to find, as it would have liked to, some statute limiting tribal authority, it really had to come up with another rationale to get to that end. Now, I acknowledge that that was a very biased view of the facts of Oliphant. There are many people who view the Oliphant decision far differently, and I am not trying to convince you to view it one way or the other, but without question, the court could not rely on what had been the principles up until this day for 150 years. It came up with a different rationale to remove tribal authority. And what the court said is, in addition to the express limits that Congress from time to time has imposed on Indian tribes, there are other limits that are not set out anywhere. It's for the court to recognize. And what the court said, and here I'm quoting, Indian tribes are prohibited from exercising both those powers of autonomous states that are expressly terminated by Congress and those powers inconsistent with their status. Now, until Oliphant, you could have put a period after Congress because that had been the rule. Now, however, you have to consider whether a power being exercised by a tribe is somehow inconsistent with its status. The Supreme Court had used language something like this in one or two prior decisions, but had never applied this language until Oliphant. And secondly, the court said, Indian tribes do not retain the power to tribe non-Indians according to their own customs and procedure. This was a decision written by then Justice, later Chief Justice Rehnquist, who wrote quite a few anti-tribal decisions. And this one really did come out of left field. Both the District Court and the Court of Appeals had ruled against Bellegarde and Oliphant, stating that Indian tribes have all the powers of any government unless Congress expressly removes them, and Congress hadn't expressly removed these. So this then is the third principle of involving tribal sovereignty. Again, to quickly summarize, Indian tribes, you begin with the concept that Indian tribes have all of the powers of any government. You then look to see whether Congress has passed a law rescinding or limiting those powers. And now, ever since Oliphant, you also must look to determine whether the power the tribe is seeking to exercise is one that they have necessarily lost by their dependent status. To summarize, some tribal powers have been lost, both by express abrogation by Congress, and courts have held that Indian tribes have also lost other powers due to their dependent status. But I want to emphasize that Indian tribes retain the vast majority of powers of any inherent government. They still are enormously powerful. And indeed, in the last 60 years or so, Congress has passed dozens of statutes, not only affirming the authority of Indian tribes, but supporting that authority and encouraging tribes to exercise that authority. Among the 60 or so statutes, here are just a couple as illustrations. One is the Indian Self-Determination and Education Assistance Act of 1975, sometimes called 93-638 or simply 638. This law really puts teeth into tribal sovereignty. It authorizes Indian tribes to obtain directly from federal agencies the money that Congress has given those federal agencies to operate programs on Indian reservations, so that whether it's law enforcement or health clinics or schools, now tribes can obtain every penny of the money that Congress has earmarked for a particular program, and the tribe will operate that program rather than the agency. So this is a huge boost to tribal self-government. Another is the Indian Child Welfare Act of 1978. This law, really long overdue, but it recognizes and affirms the primacy of tribal courts and tribal governments to determine the custody of Indian children. It's a complicated law. I wish I had more time to go into it. Those of you who do have copies of my book, Chapter 17 is entitled The Indian Child Welfare Act, and you could read much more about it. And not just my book, but there's dozens of books out there discussing this very important law. Another law passed in 2010, the Tribal Law and Order Act. This law allows Indian tribes to place people in jail, in tribal jail, for up to 3 years for any one offense, or a total of 9 years for consecutive sentences for 3 felonies, provided that the tribes provide those defendants, criminal defendants, with certain procedures guaranteed by the United States Constitution. So that enhances tribal criminal jurisdiction. And lastly, I'll mention the Violence Against Women Act, VAWA, of 2013. Just a few moments ago, I explained that in Oliphant, the Supreme Court held that Indian tribes could not exercise any criminal jurisdiction over a non-Indian. Well, VAWA authorizes Indian tribes to exercise certain criminal jurisdiction over non-Indians who commit domestic violence on the reservation, assaulting their spouse, for instance, or any significant other. This is a partial legislative overrule of Oliphant, in which Congress has decided to essentially return to Indian tribes some of the inherent authority that they had long exercised and no longer could as a result of the Oliphant decision. I'll end by referring to one more recent court decision. This is a decision by the 10th Circuit Court of Appeals. There's 13 U.S. Courts of Appeals in the United States. This is the 10th Circuit. It sits in Denver and reviews district court decisions from several states like Colorado, Utah, New Mexico. And this case, National Labor Relations Board, NLRB, versus the Pueblo of San Juan. I'll tell you about the facts in just a second, but this is a resounding example of confirmation of tribal sovereignty. The court there held Indian tribes are neither states nor part of the federal government, nor subdivisions of either. Rather, they are sovereign political entities, possess of sovereign authority not derived from the United States, from which they predate. Indian tribes are qualified to exercise powers of self-government by reason of their original tribal sovereignty. And very quickly, the facts of that case. The National Labor Relations Act, NLRA, authorizes states at their option to enact a right-to-work law. That is, a state can prohibit any government or a union, I should say, from requiring that an employee of any store or business join a union as a condition of employment. So there are a number of states that have passed laws known as right-to-work states. Well, the Pueblo of San Juan enacted a similar law, saying that businesses on our reservation could not require tribal members to join a union as a condition of employment in your business on our reservation. And the NLRB challenged that. The 10th Circuit agreed with the tribes that they are inherent sovereignties. They have a right to enact a law like this, protecting their members from being compelled to join a union as a condition of employment in a business located within the reservation. I'd like to end by saying that, as these cases have shown, tribal sovereignty not only is the single most important right that tribes have, but has long been recognized as a core principle under federal law, and that we should encourage Indian tribes to be self-governing, to seek economic and political independence to the maximum extent that they can. And I do hope that in the work that you all are doing with and for Indian tribes, that you take a similar attitude as our government has, which is to encourage tribal self-government and to help tribes participate in USDA programs. Thank you.